So let me now move on and introduce our speaker tonight. First of all, let me say it's a real honor to have Tom Goldstein here. I have my degree is actually in law, and I have a law degree and a PhD in law, and it's rare to find intelligent, good writing about law anywhere, let alone on the blogosphere. And a couple of years ago, that began to change, largely because of something called SCOTUSblog, Supreme Court of the United States blog. And this is a blog founded by Tom Goldstein and your wife, Amy, together, yes? And we had invited both of them to speak. I just want to point that out, but they have young kids and only one could come, and we appreciate that. But they sent Tom. I don't know what that means, but we'll learn. We're glad you're here. Tom Goldstein is probably the most important Supreme Court lawyer in the country today who's not on the court. He's argued 31 cases before the Supreme Court. The National Law Journal named him one of the nation's 40 most influential lawyers of the decade. And of course, something we all want, GQ named him one of the 50 most powerful people in Washington. He teaches at Harvard Law School and has also taught at Stanford Law School. And he's one of the founding partners of, he says we don't even have titles for ourselves, at Goldstein and Russell, which is, I guess, now the largest and premier Supreme Court Supreme Court law firm in the country. Is that an accurate statement?
My mother thinks so.
Yes. Anyway, he also founded, in addition to all his amazing legal work, he founded this blog, SCOTUSblog, which is really what we're here to talk about today, in 2002, if I have it right. And the first post was, "This is the birth of SCOTUSblog, the blog of Goldstein and Howe, PC, devoted to the Supreme Court of the United States." And this is actually an interesting story. The blog was originally founded, as I understand it, as part of his law firm, a previous law firm, as an advertising vehicle, as you said before. I'd like you to start by just telling us a little bit about how you started the blog and maybe how it's grown and how you see the development of it, just sort of a history of SCOTUSblog.
Sure, and thank you all so much for taking the time to be here. It's wonderful to be a part of a conversation with you all about public intellectualism and blogging and what the two, if anything, have to do with each other. The blog was a catastrophic mistake in my wife's eyes, and she has been the only person who has saved it. In 2002, there was this emerging vehicle of blogging. Obviously, the internet existed and it was decently well known, but the idea that you could self-publish and talk about something was actually relatively novel at the time. And I saw a few of these blogs being created, and I thought, gosh, what you can do is you can intellectually own a thing, a place, a topic, and people will respect you as the expert on that. And since I have a business that is devoted to the Supreme Court of the United States, why don't we create the Supreme Court of the United States blog? We'll call it SCOTUSblog, and it we'll open a free account on what was then blogger.com, and it took about, as all very dangerous ideas do, about 45 seconds from inception to fruition, and then we had a blog. And I wrote something on the blog like that, and the first day there were 35 or so hits on the blog, which we were very excited about, but then quickly came to realize that it would be too embarrassing to stop. That it would look like we were quitters, it was all a lark, but gosh, wouldn't we look stupid if we were just to give up? And here we are 12 years later, still unwilling to be so embarrassed as to quit. And it really has turned into kind of our third child. We love it and care about it dearly, and its role in the public space, we're very, very, very protective of it. For many years, right, not many is an overstatement, 5 years or so, it really was an advertisement for the blog, for the firm, and that is, when we would file a case at the court, we would say something about it. When our law clerks would go get clerkships for judges or Supreme Court justices, we would say something about that. When we received some honor, we would say something about that. And the blog kind of plodded along, growing at about 30% a quarter. In a few thousand hits, 5,000 hits, 10,000 hits, what have you. And at some point, it became apparent to me that the entire model for the blog was a complete disaster. That is, it turns out that people don't pick their Supreme Court lawyer on the basis of their website. The General Counsel of General Electric doesn't go, there's this guy, Ted Olson, who was the Solicitor General, and Carter Phillips was Seth Waxman was the Solicitor General, Paul Clement, who argued the Obamacare case. I know, they're amazing lawyers, but get me the guy with the blog. It actually doesn't work that way, and why it took me several years to figure it out is a mystery. And at that point, I realized, gosh, what maybe we need to be doing here is exactly the opposite of what we have been doing, and that is, we have been holding the blog out as a way of showing the greatness of the law firm by talking about the greatness of the law firm. Maybe what people are more interested in actually is substance, and if they really come to understand that they're not being spun, that they're not being fed something, that this is not a tool to somebody else's outcome, they will respect it more, like it more, and come more. And so I adopted a series of policies that forbade us from talking about ourselves, do the exact opposite of what we have been doing, so that we wouldn't discuss the firm's cases anymore, wouldn't advertise them anymore, and instead would try and comprehensively cover the Supreme Court in objective terms. And when our cases were involved, as we do a lot of Supreme Court work, we would have somebody else do the work. And then I hired Lyle Denniston, who's been a journalist covering the Supreme Court for something on the order of 50 years, and is the dean of the Supreme Court Press Corps, who at his advanced but still very young age fell in love with the notion of blogging and manages to work like 18 hours a day, 7 days a week. It's unbelievable. And we, over the course of a few years, developed through our good fortune a kind of profile that allows us to get really kind of any author in the law. Law professors and academics who like to think about things and write about things have an evolutionary cycle for their work measured in decades, it seems. And that is, you come up with the idea for the law review article, you draft the law review article, you send the law review article around to a bunch of students who don't know anything about what it is that you've written. They inexplicably attempt to rewrite your article. They send it back to you. You go to war with them for another 8 months, at which point they announce that, yes, it will come out in only a year. On the other hand, you could write your thoughts about the case in 10 minutes. And that's the alternative that we offer. And I actually do believe that if you are someone who's thoughtful and knowledgeable and well-read about a topic, that your best insights about it, 75% of them are going to come in the first hour. That it's true, if you think about something for months and months and months and months, your thinking will evolve, you'll articulate even better, and you will come up with more. But the return on investment is something like, boom, and then it just crawls, in my opinion. And so I think that we have a variety of authors who think that we are, a good way of getting out there. We also have an audience that's exponentially larger than the law reviews now. So we were very lucky in terms of the people who were willing to write for us. And then kind of our moment in the sun, I suppose, was Obamacare, where you have to deal with a series of incredible specialists to realize that when the opinion comes down, you should read it. And then you'll be more likely to correctly say what has happened. And there were some television networks that decided to go in a different direction and report the opposite of what had happened. And so there was kind of a moment when people became much more aware of the blog. The blog on that day had nearly 1 million simultaneous readers. And that's kind of the way it goes for us. The Supreme Court, at the beginning of the summer, at the beginning of July, the justices finish the term. They have to get to very important chamber music festivals in Europe, and kind of the place shuts down. And there isn't a lot going on. We kind of really struggle. So we run symposia and that sort of thing. And the public's interest kind of waxes and wanes when the court is going to decide whether there's a federal constitutional right to gay marriage. It turns out a bunch of people tune in. When they have, the most recent interesting thing they've done is a month ago, they decided to hear an ERISA case. Well, then it's kind of crickets out there. And so the delta between our kind of minimum and maximum readership is astonishing. But it does seem to be the case that there's a chunk of the population that when they decide that they want kind of to understand what's going on in the Supreme Court now, they are good enough to come see us.
Could you just walk some of the people here who maybe aren't as familiar with the blog through how you cover a case like Obamacare? Because that was an extraordinary event.
Sure.
And what Tom was referring to is that a number of the press reports initially got it wrong, actually announced the wrong decision.
Yeah.
And suddenly everyone was going to SCOTUSblog to find out actually what was going on and what was happening.
No, it was a very weird situation. The court's own website crashed, so the president found out through the blog because the administration couldn't get a copy of the opinion. So we try and cover every single Supreme Court case from soup to nuts. Now you think, gosh, that's a lot. I'm here to tell you your Supreme Court doesn't do a lot. And that's awesome for us. They do decide about 80 merits cases a term, which is actually a perfectly significant workload, but it's not like there are thousands of cases that they're actually deciding. They are having to go through thousands of petitions asking them to review. So they take from those about 80 cases that they're going to hear, and so we cover the case at the petition stage, and then there'll be an oral argument, and we'll write a piece about the case before the oral argument, and then we'll describe what happened in the oral argument, and then we'll describe the opinion when it's released. And for major cases, so for this term, you'll have heard that there is a big controversy about the contraceptive mandate of Obamacare, the Hobby Lobby case, as it's applied to closely held companies that have a religious ownership. So a family owns the company, they don't want to have to provide contraception to their employees. Does it violate their religious freedom to make them do so under the Obamacare regulation? So a case like that, we might have, our coverage of the case, we try to make as objective as possible. And that is, our theory is that we will provide you information about the case, what has happened, what the arguments are, what the court has done, and then you can develop your own opinions about that. For the kind of raging controversies of the day, we will have 3 or 4 opinion pieces, the way you might think of an editorial page. And we try and be very, very prompt about it. So we, on a day in which, towards the end of the term, in June, when the court is finishing up and handing down its most significant opinions, that usually at the time, because they've been the most difficult, they've been the back and forth between the majority and the dissent. So we'll go to the court to report on the opinions. We have the weird situation, though we devote enormous resources to the court, the court uses us very heavily, the court refuses to recognize us, which is another weird thing about blogging. It's a weird thing about blogging and the fact that I practice in front of the court. They don't quite know what to do with us. So we work out of the cafeteria. And so they allow Lyle Denniston, our reporter, to report from the press room because he has a credential from WBUR, the public radio station in Boston. But the rest of us will kind of huddle in the cafeteria of a kind of virtual computer network with a whole bunch of different machines. And NBC uses us at the end of the term too, and so we'll just have people running around trying to get hold of the opinions and say what happens. It's kind of a messy, imperfect process, but it certainly is, I hope, managed to get more information about the court out to the public.
Okay, great. So I want to, the blog is really structured as sometimes as almost a public service.
Yes.
It's a blog. You have opinion pieces that are there, but that's not the main aspect of it, and I think you've made that clear. I'm wondering, who do you imagine your audience? I mean, I'm sure you've probably done some research on this. You know who your audience is. So could you tell me who your audience is, and who are you not reaching that you want to reach, or who are you surprised that you're reaching who you weren't expecting to reach?
So the audience has evolved and, as a consequence, divided over time. We were writing to people like us for a long time. The 35 people who came and visited us on day one were either people who were lost or were Supreme Court practitioners. And then over time, we got the Supreme Court fanboys and fangirls, and then we got the law students. And that was kind of it for a while, right? There were a bunch of people who, our vernacular, the way we talk about the court is, originally was at a pretty darn high level. It's like, if you were going to a philosophy blog written by a bunch of philosophers, I wouldn't have any idea what they were saying. You might. But the members of the public generally wouldn't. And it was kind of like that for us and the Supreme Court. Over time, as we got better known, we have really struggled to deal with the fact that our highest and best use is actually not talking to the lawyers who already know a fair amount about what's going on at the Supreme Court and we're just filling in details, but the broader public, which has no earthly idea, because it's very hard to find out. The Supreme Court is a very opaque institution. What's going on? Cameras in the courtroom being one example, but the Supreme Court's own website doesn't have like a clearly stated list of here are the issues in front of the court and here are the arguments and here are the decisions, just as an example. They really believe their role is to speak through their opinions and leave the rest to others. So we have data on the readership, and it produces the following very interesting result for me. So we have our ordinary coverage of case, and then Amy, for the most significant cases of the term, writes a feature called whatever the case is in plain English. And that is, it's intended for our non-lawyer audience. And if you look at our survey data and you rank the importance of look at the data, ranking the importance of features and how much the readers like features on a scale of 1 being the best and 5 being the worst, in plain English is a 4.5, almost at the bottom. But if you then cross-tabulate the data to people who do not have a legal education, it's uniformly a 1. And that is, the lawyers hate it, view it as kind of like dumbing it down, it's beneath them, it's stuff they already know, it's too simplistic. But there's a huge tranche of the readers who are like, thank God somebody just stopped and said this in real words that I can understand. So that's been very, very valuable for us. And we now, for all the cases, will actually have our summary, and then at the end we will say, in plain English, here's what happens. It creates a real problem. A newspaper like the New York Times, a magazine like the New Yorker, has dilemmas about at what level it's going to write. We have those on steroids because there's a huge terminology in the law, but there are also just subjects in the law, like how in the world would I write? Here, I'll pluck 2 examples, the cases that I argued in November and December. So in December, I argued and won a case that is about whether, when a party under an international investment treaty seeks arbitration without first exhausting local remedies, the arbitrators decide the case, it goes to court, do the judges review that question de novo? There is no plain English version of that statement. It doesn't exist in plain English, and so how is it that you try and articulate? And then you ask yourself the question, I spent 7 hours converting this into plain English and no one cares. Right? That's the other thing, is you have to know which part of your audience cares about which cases. The other case that I argued in November, the Supreme Court decided that for victims of the Stanford Ponzi scheme, so this is something that people care about. This was the guy who was operating the Stanford Investment Bank out of Antigua. He was offering certificates of deposit. He collected $5 billion from people. It turns out that he was actually buying polo ponies and Caribbean land, which he was not supposed to do. And so a bunch of people sued his advisors. And so they brought state securities lawsuits. And the question was whether those suits are preempted by a statute called SLUSA, the Securities Litigation Uniform Standards Act, which involves the application of very complicated provisions of Section 10b-5 of the securities laws. Completely impossible to truly describe in language that a non-lawyer would understand or care to understand. So, that is a problem that we face every day. In terms of people that we're not reaching that I want to be perfectly honest, I don't really care about the lawyers. Well, here's a weird dilemma, and that is, it was costing me, as of about 3 years ago, it was costing me $250,000 a year to run the blog, just out of pocket. I was just lighting money on fire. And then I realized this isn't really sustainable, so Bloomberg Law came in, and it's the sponsor of the blog, exclusively, has a little banner, I write some things for them. They're unbelievably good to us. They are advertising this service they have that competes with Westlaw and Lexis, which are the big legal research programs. And they really care about the lawyers and the law students because those are the people who are going to use that product. They believe in the public service interest mission of the blog. But I am very, very, very interested in the 300 million-ish people who would be interested in their Supreme Court if they knew about us, helping them understand what that part of the government is doing. The resources devoted to covering the Congress and the White House are exponentially larger than the Supreme Court. It's not even, it's not even close. And so I'd like to be that resource for still more people.
Right, and that's really interesting. I mean, so the Congress and the White House are democratic branches of the government. The court has always been, as in the phrase, the non-democratic branch.
Sure.
As you said before, they're somewhat skeptical of this. They almost want to be in the shadows.
Yes.
Hannah Arendt is fond of quoting a statement by Woodrow Wilson that the Constitution in the United States became important when it became worshipped. And I'm wondering, it strikes me that almost you didn't start the blog with this as your goal, it seems, but it's become a goal for you to sort of make the Constitution transparent, make what the court does transparent, which is not an uncontroversial claim in the world of law and constitutional law. And so I'm wondering how much you're worried about that. Do you worry about how much you should make it transparent? Is there a worry about giving people too much information about the way the court works so that they'll have less respect for the Constitution or the Supreme Court? Or is it, we're journalists, we're transparent, this is our mission, and we believe in it without hesitation?
Yeah, there is a kind of elite vision of things that takes my point about, hey, I can't explain the SLUSA case, and I can't explain the International Investment Treaty case to an ordinary American who doesn't care about it anyway, and takes that and kind of puts it on steroids and says, I think that the Supreme Court in general and the American Constitution are there are only super expensive, cool lawyers like me who can figure this out. Everybody else just take a chill pill and I'll let you know when you need to be concerned. And so I am not a believer in that. I try to be a realist about when it is that I can genuinely expect someone to engage what the court is doing. And in those times, I will open every conceivable door. I don't have this expectation that a member of the general public cares about 9 out of 10 things the Supreme Court is doing, because it's very technical legal stuff. We think about abortion and affirmative action and gay marriage and things like that, but those are the exception that proves the rule that most of what the Supreme Court does is very boring. You just have to look at any of my cases to know this. I do the boring ones. That said, as to the question of what it's like on some level to further democratize the Supreme Court, it is a weird institution in the sense that famously it's only, as was said at the time of the core desegregation era, you can say back to the Supreme Court, you and what army will cause me to desegregate these schools, right? The Supreme Court has no force but that of its, the level of respect that's associated with it. It doesn't have any power beyond that. There is a general consensus that we're going to do what it says. That would have been tested enormously in any other country in Bush versus Gore, where there would have been riots in the streets, think it right, think it wrong. It was exceptionally politically divisive and thought at the time to be dispositive of the presidency. I believe in the demystification of the Supreme Court on questions of across the board of whatever the public's interested in, that equates to the big, sexy things. The Supreme Court is fundamentally a policy-making institution. I'm sorry to say that the court isn't looking at the text of the Constitution and coming to some objectively verifiable understanding of the meaning. The Constitution tells us that there won't be unreasonable searches and seizures. What in the world in the era of a cell phone and GPS tracking does that mean? The Constitution says that Congress shall make no law abridging the freedom of speech, right? No, of course it can make some laws that infringe on freedom of speech, but how much is too much? And what do we mean just Congress? Can a state abridge the freedom of speech? The Constitution, unlike the Constitution of many other countries, more modern constitutions, European and African, South Africa's Constitution, those things are incredibly detailed. They are like jot and tittle, da-da-da-da-da. The framers of our Constitution wrote a thing a long time ago, wrote in very vague terms to deal with a bunch of problems. And so the justices, there is a wildly divergent range of possibilities. The same document today is very fairly said both to support and not support the notion that there is a right to gay marriage, and to an abortion, to prohibit affirmative action, to guarantee you the right to carry a gun in public. Right, all of those are in the range of acceptable discourse about our Constitution, easily so. All of those would divide the Supreme Court 6-3 or 5-4, in fact. And given that the court is making policy-based judgments in the end, albeit founded in principle, about such incredibly important features of our lives, it seems to me wild that we would just kind of say, I trust those 9 people. Particularly when the Constitution is actually designed in a way that, in theory, you would vote for a president on the basis, in part, that they will appoint Supreme Court justices of a particular ideology, and thereby shape the nature of the Constitution. If the public loses faith in the Supreme Court, it will be for one of 2 reasons. One is they will do something that is a fantastical overreach. They'll do something worse than Bush versus Gore, which managed not to do it. Or the kind of way television, cable news looks at the world and talk radio looks at the world will just take hold. Right? Every other institution in the United States has kind of done itself a great disservice by its own actions, and then commentators have come along and kind of talked poorly enough about it that people lose faith in it. If you come to SCOTUSblog, we respect the place a ton. You don't see us trashing it. You see us describing it. And so I hope that we don't contribute to the loss of faith. And instead, I'm a believer that the more you know about your Supreme Court, the more you will actually trust it. That's why I think there should be cameras in the courtroom.
So you and I were talking about this briefly before, and I just want to follow up a little bit on the last part of what you said, that you think SCOTUSblog has great respect for the court, and that you think that it would generally encourage that, right? And I think I largely agree with that. The question I have is this: a lot of the way insiders talk about the court is things like, do we have 4 votes? Do we have 5 votes? How do we get this one vote? We isolate this judge and that judge, and people talk about it as, well, we have to frame the argument this way to get that judge, this way to get that judge,
Yes.
and they make it seem like a personal discussion about each judge.
Yes.
And people have done so much research with regression analyses and all the kind of things that they sort of can isolate what words they think this judge might respond to and what words that judge might respond to.
Yeah.
And when you start bringing that conversation to the public, it's hard for, maybe I'm just mistaken, but it might be hard for people to say, oh, I respect this institution, the Supreme Court, that's got 9 people unelected, appointed for life, that are making policy decisions, as you put it. And the more we hear about that, it's going to be harder and harder for people to uphold this sense that the court is different, that it has an authority.
Yeah.
And I'm just wondering to what extent you think that's the right view or the wrong view, and how you think SCOTUSblog plays into that discussion.
Well, a lot of what I think about this is obviously colored by my job as an advocate. My job is to persuade people that they need to pay me $1 gazillion because I'm the one who can tell them, what color tie. But there is a Kremlinology to Supreme Court advocacy that is, my job is to think about a legal problem not in terms of what the objectively right answer should be, but how 9 different people will think about it, as I spend my entire life thinking about how those 9 people think about the problems. And that, no doubt, informs the general approach of the blog. Now, the plain English stuff, we'll say, the decisive vote here is Justice Kennedy or Chief Justice Roberts, or whoever it is on a particular issue. It can be Justice Scalia, a very solid conservative. It's my view that there really are 9 different people tackling a problem, and in their own distinct ways, of which there's substantial overlap. In the same way, if you got 9 smart people in a room and anything, there wouldn't be 9 entirely different approaches to it. That people would coalesce around some theories, and that it actually doesn't deserve one's confidence in the court to know that they aren't voting as a block, right? It's not just, I presented the case, the 5 conservatives voted against me, and I went home. That it is more subtle and more nuanced than that, that they're more serious people than that they work harder at it than that. I suppose that the potentially loss of confidence inducing version of one's take on the court would be that they're manipulable, or that is what I call a policy-making institution. They are doing it more on whim and caprice, and their desire for the outcome, which is how most policymakers act. And I don't mean to suggest that. That is to say, I don't think they're trying to shape the world in the way that they think would be best. Rather, they view the Constitution to embody a set of policies, and wildly different policies, depending on the justice. And they have generally speaking, have a consistent vision for what the Constitution means, and a consistent vision for how Congress enacts statutes. And we ought to recognize that it's not that they can, in a kind of Talmudic sense, look down, here I see the words, and hence I have the answer. By policymaking, I mean that there is a lot more plain in the joints of the U.S. Constitution than people want to acknowledge. And we want to demystify the process by which they're trying to get to the right answer.
That's great. We have, on another note, we have a bunch of younger people in the audience tonight. Some of them may have tried blogging, some may not. What do you look for in a blogger? You hire bloggers, and here's our colleague Walter.
Perfect timing.
Perfect timing. This is, in fact, one of the questions I have to channel. Hey. Welcome, Walter. What do you look for in a young blogger? What makes a good blogger today?
Well, I think that there are several characteristics that are going to be important in blogging. One is you have to really love your subject matter. Blogging, it's relatively rare that you wake up, you blog, and then you look down and someone has dropped off the wheelbarrow full of cash. It is going to be a situation in which a lot of what you're getting from it is the self-fulfillment of really thinking about and writing something about what is near and dear to your heart. And it's very, very hard to blog. You're going to have to build an audience. You're not going to just kind of open it up, develop a URL, and suddenly thousands upon tens of thousands upon hundreds of thousands of people are going to show up because they know just what's buried deep in your head, and it's a diamond just waiting to be shaped. Rather, it's going to take a significant amount of time where you're going to have to engage a community of people who are writing on similar issues. They're going to have to come to respect you and write about you, and that means that from inception to fruition, it's going to be a potentially years-long process before you get the respect that you may rightly feel that you deserve. And you're not going to keep doing it, given all the other demands on your time, unless you are just so excited to sit down at the keyboard and have the opportunity to say something about this. You are, generally speaking, going to want, on that subject, to have an opinion. SCOTUSblog is the exception that proves the rule that most blogging and most good blogging is not newspaper writing. It is someone who has taken the facts that are available to us all through the internet, through picking up the newspaper, through picking up the New Yorker, and then giving you a really interesting novel take. And if you're not either pedantic about it or insulting about it, people really who disagree with you nonetheless will read you and will respect you and will engage in a respectful, entertaining, interesting debate back and forth with you. The advantage of blogging is that it's super cheap to do. Its cost is essentially time, and time is zero-sum, and time has a monetary value attached to it. And so you're going to have to realize that while you're not going to have to pay a lot of cash to blog, you're not going to make any cash blogging. What you are going to do is you're going to make other sacrifices. You know, when you sit down to write that piece, you're not going to go have dinner with friends. You may not spend as much time with your family, and you're going to have to derive the self-satisfaction initially of knowing that you really are expressing yourself. You know, I think those are probably the principal features. In the people who write about cases for us, it's a very unusual situation. We deal with subject matter experts, right? So the reason that we brought the person in is they know about this random question in tax law, and I couldn't possibly ever want to figure it out, so I can more efficiently go get somebody else who really does know about it. But when we're doing opinion-related pieces for the cases, that's the kind of thing we're looking for, is that people who have over time really shown it. So I can't just go get the person who I think is the most knowledgeable about it. I need them to be bloggers, because I have to know that they'll deliver in a very discrete period of time. There are people who are book writers, and there are people who are bloggers, in my opinion. It's actually relatively rare, and Andrew Sullivan, some of the folks here, who can do both. But generally speaking, you are kind of a long time horizon person, or you're like, sweet, I can do this in 30 minutes and go get drunk. And you know, I'm looking for the latter.
Aren't we all?
Yes.
And so, are most of the bloggers on your site then practiced attorneys in their second, third careers? Are they the Lyle Denniston types, or are they? I know you also have law students blogging. How do you think students do as bloggers, in your opinion?
We, for a long time, used our Stanford and Harvard students as bloggers, and have largely, actually entirely stopped doing that. They were an incredible resource for us. They would try very hard, but what they could do is they were smart people. They would go and read the briefs and recount what was in the briefs and what the arguments were in the case. And I think that if you are going to go to the trouble of writing something, you ought to be able to provide context that's not available from just reading the briefs or the opinions, some form of opinion, some sort of prediction about what's going to happen. And that requires an amount of wisdom, not just intelligence. And so when the blog became more prominent and we could get basically whatever law professors we wanted, we turned to them and stopped using the law students. And so right now, most of the people who write we have repeat player staff who write about particular subjects, and then for the kind of random 50 or so cases in kind of hidden areas of the law, we go find the person that we think would be both knowledgeable about that issue and is a blogger of some kind.
So it's interesting. What you're saying is confirming something that we've heard in a number of these conversations. People talk about blogging as a sort of young person, all that tech stuff, how young people are with tech, blah, 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 blah. But in fact, a lot of the bloggers that we've talked to of various ages have said in some ways blogging is something for somebody who has a few years under their belt.
Yeah, I think that's very well put, and that is, the technology isn't a barrier. There are things like, you can even take something as simple as Twitter, what I now recognize to be something as simple as Twitter. We can talk about Twitter, and it can erect a generational barrier, because it is so orthogonal to anything that it doesn't translate. It's so weird. There is no prior experience for my generation or any generation older than me that equates to. Blogging is kind of like a very, very fast public newspaper in a sense, or a public opinion piece. And so we're capable of getting, all right, I get it. And then you just log on and suddenly you're typing, right? There aren't walls in your way. Then, we're past form into substance. And in terms of substance, if you really want to write with depth, which is to say, you're going to be respected for a subject. People will come back because you know what you're talking about in this field. That requires a measure of experience to have seen and to participate in the debates and be able to analogize this situation to something else that you saw 7 years ago or 27 years ago. And so, to take an example, our reporter, Lyle Denniston, is, he would say, old. But he is exceptionally talented. He's a newspaperman, and so this form does nothing to get in his way, and he generates a huge amount of content, much more so than anyone literally 80 years younger than him.
I will say, we have a blog at the American Interest, Peter Berger, on religion, Peter has refused to learn how to use WordPress.
Yeah. So he just types it into like Word and
And sends it in an email, and then we have to put it in. So
It's
there are
funny.
some technological barriers.
Right, well, it's very funny because WordPress every once in a while, we're built on top of WordPress, and WordPress every once in a while will have some sort of glitch, and Lyle will lose a piece. We keep trying to get him to write it in Word, and he emails us, no, he wants to be in WordPress.
Well, but now, can young people blog? And what's the strategy for a young person that would want to sort of start out, as opposed to somebody who's already got all this experience and context?
A young person, there's no age limitation. Blogging is a reflection of either some combination of experience and interest, and interest can trump a lack of experience. And that is, if you are a young person and you are really particularly interested in to take something more kind of unintellectual just to start from it, take the youngest possible person who's very interested in kind of movie or kind of music. If you are going to spend your time thinking about it, enjoying it, living in it, reading what other people are saying about it, and participating in a conversation about it, I think it's absolutely possible to do that. You are not going to be able to write the piece for some time that says, until you have really experienced kind of how it relates to jazz and other forms of music and those sorts of things. But if you say something interesting and intelligent, people will read it. It turns out that most of the things on the web are stupid. And people actually are looking for things that interest them and intrigue them and hold their attention and are new ideas. And if you are writing about something that you care passionately about, you are going to be creative about it. It's very rare that someone says, I am destined to think about this topic. You know what I think about this topic? I think about only the things that I read about this topic yesterday. When we are writing about what we love, as opposed to what we have to write about, or what somebody told us that we had to write about, or what you think there's some expectation that you will write about, then you are apt to be really, really, really fascinating. And the fact that you are writing about it, and there will be expectations that people will read what you're writing, will cause you to do an even better job. So I wouldn't say that someone should just kind of, say, I can come to this and write about it in 5 years. There is something to be said for the younger you are, you may have the free time and the lack of family responsibilities and other professional responsibilities that will allow you to actually do a good job. But that said, I think the best writing comes from experience.
You said you turn to professors a lot.
Yes.
Do you find that they are good bloggers?
No. Because we don't just turn to professors. The threshold that I tell my staff is, go find the person in this field who blogs. I think that what I want is a blogger. It is absolutely essential. If I go get some genius level law professor, there is too great a chance that they will say, I'll get you the piece on date X, which is when I need it, and they'll have just gotten the year wrong. I just can't. The blog is built on an editorial calendar and a schedule, and things have to come out when they're supposed to come out. An editor is going to read it, and all of these sorts of things. And so I will take, 20% worse substance. I will not let the perfect be the enemy of the good. And the perfect is like the ultimate piece on topic X that doesn't get published in time, versus the good, which is it got out there and people were actually able to learn from it. In the main, law professors didn't get into that field because they love doing quick, short-form pieces. A law professor knows that their excellence is measured by these super long law review articles with a gazillion footnotes that span 100 pages that no one will ever read, and to convince them that instead what that we need is 800 words that 100,000 people will read.
And what is in the 800 words? What are you looking for? What do you want in that 800 words?
It depends on at what stage of the case, because different things are going on in the Supreme Court at different times. At the very beginning, I want to know what the question is, why the court agreed to hear it, and what the case could mean. Before the oral argument, I want to know what each side has said about the question. After the oral argument, I want to know what happened and what the best prediction of what's going to happen. And that when the case is decided, I want to know what the ruling was quickly, but people can go read that, and what was the reasoning and what's going to happen from this. That's one of the things that happens with Supreme Court cases is that they tend to be dealt with on kind of the The New York Times the next day, we the next day will write, here's what happened. But the reason the court took the case is not because of these particular litigants and these particular facts, but because the case has much broader implications. And I think that we in the media do a bad job of big picturing it. Like, here is why they took this case, here's what it's going to mean for the next 20 years, here's how it intersects with a bunch of other cases. And again, that's something that comes from, is not immediately apparent a lot of the time and requires someone to have a broader context than a law student being able to kind of read an opinion and parse it.
Is there, oh, go ahead.
Well, yeah, forgive me if this subject already came up, but it does seem to me that one of the things you guys have done, you've dramatically improved the quality of legal reporting that's accessible to a wide audience.
Well, I would say that our peers in the Supreme Court Press Corps do a very good job, but with a much more limited scope of assignment, and that is, I think that the reporters from, just to pick examples, the New York Times, the National Public Radio, the LA Times, all of these people are actually very talented at their job, very committed to it, no question, not inconsistent with what you said at all. What we have done is we have then said, okay, you're going to cover the big 15 cases of the term, we're going to cover all the cases of the term. And there is some value in that. I think that the cases number 15 to 30 can be decently important. And we also serve some other roles where we have this archival function, we provide the briefs, which bizarrely are very hard to get otherwise for free. So I appreciate that very much. I think that the odd thing is, or maybe it's not the odd thing, that we are all well aware of the kind of collapsing resources that surround the classic medium. The Supreme Court Press Corps has a lot fewer people, and people who are divided in their attentions with other responsibilities than just governing the Supreme Court. And that means that by hook or by crook, the blogging and other forms of media are going to become more important in terms of getting information out. And that is a generalizable principle, and that is, there are lots of things that there's lots less press coverage for, and it creates the opportunity for blogging to be much more influential. Just to play out the example, 5 years into the blog's history, blogging was still regarded as kind of like, right? By year 8 or 9, the press corps was kind of very actively citing us and other bloggers as experts in the field. At year 12, we're regarded as the competition. And so there's been a very significant evolution in how our relationship and our role and the level of respect we have in the press corps.
You said you focus on, let's say, 15 through 31.
Yep.
Cases 15 through 31. How much does your readership follow cases 15 through 31?
Well, cases 1 to 5 are going to get, and it's again going to be a question of what readership we're talking about. In terms of the general public, cases 1 to 5 are going to get humongous attention. In terms of our non-repeat player readers, people who show up on the blog 5 days during the year, they're there for gay marriage, affirmative action, Obamacare, the future of the Voting Rights Act, stuff like that.
Right.
That's when they have just really decided, or somebody else has linked to us or something like that. And so we will get peak readership on those days when those cases are being argued and decided that are 5, 10, 20, 50x what our readership ought to be. Giving the example of 900,000 simultaneous readers on the blog in one day. The cases 25 to 30 tend to be someone who's particularly interested in a particular topic, or we have general public fanboys and fangirls of the Supreme Court.
How many of those are there? Do you have a sense of your community that is a reliable people who want to read the blog on a weekly or daily basis?
I think there are 50,000 of those people.
That's a lot.
Yeah, that's and it depends on how you extrapolate, what else you're going to say about them. So if you have 150,000 Twitter followers, right? So how do you count those people? And I don't really, I've blown hot and cold about what that means and whether it means anything at all, and I think it means very little.
Most people have so many things coming on their Twitter feed.
It's very hard to, I thought, so for a while I had turned to, when the Supreme Court would do something, I would first break that news on Twitter. But my level of engagement from a reader on the blog for a Twitter follower is astronomically higher for exactly the reason that you give. People will see it on the Twitter feed, and we can have tweets that are retweeted thousands of times. But if you come to the blog, you came to read the blog. And so I now focus more on the blog. And so I would say I expect there are 50,000 core readers, and in any given week there'll be another between 50 and 500,000 other people kind of randomly.
Have you ever had any feedback from the justices about what you did?
Yes, we have. Some of it has been complimentary. They're super nice about it. We have a very strange relationship with the court. If you talk with the justices, they say that they love the blog. They're nice people. Who knows what they really think? They use the blog a
On the
lot.
other hand, they don't have to care what anybody thinks.
They don't, but they tend to be. Well, you know who they care what they think. They care what the press thinks.
Yeah,
about
that's
them.
right.
Everybody cares what the press thinks about them. It's very rare that someone will walk up to a reporter that covers them and says, "I think you're a friggin' idiot." It just, there's no angle in that. But they are very kind about the blog. They are our heaviest user. The court is our heaviest user, including because, weirdly, it's much easier for someone who works in the Supreme Court to get the briefs from us than from the Supreme Court. It's a very strange situation.
There's a lot of modern history in that statement, in the sense in which the speed of technological change in government is so much slower. Maybe NSA accepted. But
well, they would say that they have now decided to put in passwords. So I think that the court, that we do occasionally get feedback about something being inaccurate. Most of our semi-formal communications with the court are about one of two things. One is about whether they're ever going to give us a press pass, and the second is they will use this as as a means of distributing information.
Mm-hmm.
There are things that the clerk's office or sometimes the public information office wants the public or needs the public to know, and we will help them get that information out. Only in the way a newspaper can't, just because we're so devoted to covering the court, it's not anomalous for us to help pass on.
So it's got to be something that some of your contributors must think that the commentary they're writing about one of these cases may well be read by one of the justices. It's a great privilege. You're, in a sense, submitting a non-brief brief or something.
It is our biggest dilemma. This is a huge problem for us. I am a very strong believer in what is an ethical principle that is not actually a recognized ethical principle, and that is that you should not try and influence the court outside the normal processes. That ethical rule extends only to the lawyers in the case. I believe it should extend more broadly. I believe in the process. And it's informed by the fact that I'm a lawyer and I don't want somebody else messing around in my case. I want to know what the arguments are. I want to present them in the normal way. We get pitched all the time to highlight, every day virtually, to highlight a case, to highlight a piece, that sort of thing. And navigating that to try and find when people are objectively writing about something, even if it's from a perspective, but they aren't just trying to manipulate the process,
Right.
is super hard, and it's actually very important.
It's important in all forms of journalism. There are people who have an opinion but are still trying to shoot up the middle, and then there are people who are consciously trying to tweak the way readers will think.
Yes, there's a huge amount of spin out there. And this is a real problem, both for whether our readers will come back because they think they're getting the straight skinny from us, and also whether, and this is a huge deal for us, whether the justices believe that we're manipulating them.
Right.
And this is a problem for, there are times, I'm very candid about there are times where my two jobs here overlap. And that is, if the justices don't like SCOTUSblog in the sense of it, they can know we can criticize them. They're thick-skinned. We do criticize them. I've testified that I think they're doing the wrong thing in Congress. They don't have a problem with that. But if they think they're being manipulated, they can get very pissy, and understandably so. And so it's there are things that we do to stop what we think would be perceived as manipulation that wouldn't even be manipulation. One example, to take something simple, is that now it's a rule that Lyle Denniston, our reporter, can't cover our cases. And if anybody were to ever read Lyle Denniston's coverage of my arguments, they are rarely flattering. Guy does not hesitate to call it like he sees it. He says terribly mean things about me that make me cry. But we now have a rule so that nobody thinks that anybody who reports to me will ever say anything about any case that I'm involved in, stuff like that.
This is interesting too, because I think for younger people or people wanting to enter the field, it's this is new territory, and there are a lot of unwritten rules that are popping up that as you move into a blogging field, what's appropriate, what's not appropriate, can be a little bit different from a newspaper writer.
Yeah, it's really interesting. There are a whole set of norms that have grown up around blogging. They involve things like engaging a community and how much you're linking to other people and giving them credit for things. And so, it is, interestingly, the most individualistic thing you can do. You can open up a web account, get on there, and write what you say. But you can find yourself enormously isolated. And that is, in order to be read, you're going to have to be a part of a community in some sense. You're going to have to be respected. You may not have to be agreed. People don't have to agree with you, but they're going to have to agree that you're doing something thoughtful, that you're worth reading, that you're worth taking their time with. And that's going to require complying with, generally speaking, a variety of conventions. Now, if you are some superstar and you are, the Hannah Arendt of your day, and you just write things of such incredible
or even
wisdom,
just the Justin Bieber, your following will not
right,
go away.
Exactly right. You can do whatever you want. You can pee on the tree, and you can do whatever. That was Justin, not Hannah.
As far as you know.
I have some scholars here who assure me that those two will be the exception that proves the rule. That you're going to have to play by some rules, and you're going to have to. One of the dilemmas is people who blog tend to be extremely opinionated. That's what keeps them going, and that is they get up and they feel like they have something to say. But in order to have people want to read what you have to say, you have to be very respectful and interested in the opinions of others.
Any of the justices ever offered to write anything, or have you ever asked?
Yes, the justices have written for the blog. It's also a very touchy situation. They have not written about their cases, of course, but they have written various kind of tribute pieces that we've published because it's easy and we set up firewalls for that too. I don't deal with them in the course of that. We have had retired justices write, but the Chief Justice has 2 pieces on the blog last term, short pieces, tribute pieces, and so does Justice Kagan. Staying a million miles away from the cases and stuff that they would have done for anybody if they had asked. It doesn't signify any particular role or special place.
Which of the justices would be the best blogger if they were bloggers?
If anybody who's read Justice, I'm a believer in, you're going to be a great blogger if you're interesting. And anybody who has read Justice Sotomayor's autobiography knows that she's a fascinatingly interesting person. So too with Justice Thomas. Incredible life experiences, a real willingness to express oneself. The justices tend to be extremely reserved, lawyerly, boring people. That's kind of what is part of their success. And the experiences they've had in their lives, I think, would be fascinating, as reflected in their books.
Do you have a sense of what the Roberts Court is going to be thought of as you probably watch it as intensively as anybody does?
Well, the winners write the history books, and it is not entirely clear who the winners are going to be. The Supreme Court's experiencing something of a demographic bubble today, and that is we have 5 justices in their 50s and 4 justices in and around their 80s. Late 70s.
Are very important.
Yeah, that's absolutely true, and so too the presidency, and that is 2 justices on the left, Justice Ginsburg and Justice Breyer, 2 justices on the right, Justice Scalia and Justice Kennedy. It is wildly implausible as an actuarial that they will make it through to 2020. So the court is going to change, and it is going, in all likelihood, to lock up a majority in one of 2 ways, and that is the court has moved significantly to the right. When Justice O'Connor retired and was replaced by Justice Alito, it could move still very substantially to the right more. We talk now about the realistic prospect of recognizing a right to same-sex marriage. Roe versus Wade hasn't been overruled. Affirmative action hasn't been banned. All of those things hang by a thread of a vote in the Supreme Court of the United States, probably.
One vote.
One vote, each one of those. And so, if one of the justices, if the court were to move one step to the right, that would be very significant. It would be still more radically different if the court were to move to the left, if a Democrat replaced Justice Scalia and Justice Kennedy. And the court would just swing quite dramatically back to the left, because there are a whole range of things that the Roberts and Rehnquist courts have done that the left of the court stands ready, willing, and able to overrule. I think that he, as a Chief Justice, like Chief Justice Rehnquist, his mentor's an overstatement, but he clerked for him, they were close, same model of a person, will be regarded as great Chief Justices. They did with Rehnquist and do with Roberts an exceptional job managing the institution, and they're actually, the interesting thing about the title of that job, it's not Chief Justice of the Supreme Court, it's Chief Justice of the United States. They sit atop the entire federal judiciary, and so they have a huge number of responsibilities, and I think have done really good jobs. People don't think great things about their predecessor, Warren Burger, who's kind of thought as a political guy. But I think that Roberts himself personally will go down as a very admired person. Whether he will control the court, it's too early to know.
Maybe we should open it up to some questions if there are any from the audience.
For now, maybe I'll start one. You on the healthcare, the Obamacare case.
Sure.
You, if I'm not mistaken, rightly predicted that Roberts would write the decision, and that the decision would go in the direction that it did, upholding the law.
Yes.
I'm wondering, I don't know if you predicted the tax, that it would be solved on would be decided on the tax issue.
Yeah.
I'm wondering if you could. It was obviously the most important moment in your blog, the SCOTUSblog history. If you could talk a little bit about the way you thought that decision played in public, and the way it either helped or hurt the reputation of the court, and whether you thought, and how you took the court's way to decide it according to the tax issue and having Roberts write it.
Sure. So, the great thing about predictions is if you do them enough, you will inevitably be right. And so I predicted the outcome of that case in 8 different ways. And one of them turned out, on the Daily Show, I will say, through nothing but good luck, my predictions tended to reflect what was going on in the court at the time. So I went on the Daily Show and I said that they were going to lose, and it turns out I think that at the time the administration was losing. On the day before it came out, I wrote this thing saying I think it's going to be Roberts and I think the administration is going to win. And my reasons, not worth getting into here, my reasons were completely wrong. It was just dumb luck. In terms, but you put down your marker and then you just claim credit. That's another essential thing about existence, and that is just forget all the times you get it wrong. I've predicted correctly each of the last 5 Supreme Court nominations only by suggesting 1,000 different people will be nominated. And one of them reached nominated.
But the economists who predicted 7 of the last 4 recessions.
Exactly right. So, with respect to how the case is perceived, there are several legal doctrines inside the case, 3 big ones, about the Congress's commerce power, how it can regulate commerce between the states, Congress's taxing power, when it can levy a tax, and Congress's spending power, when it is that it can make the states do something in exchange for federal money. I think all of that flies over most people's heads, and that is the bottom line is what matters to people, and that is Obamacare, and in particular, this all hinged on the individual mandate part of the statute, is it constitutional? And the narrative that sets in is that the Chief Justice saved the statute. I think that he did that because that's what he thought the right answer was. It is perhaps the single greatest example of kind of blogging and public intellectualism, the influence blogging had on that case and how it almost destroyed the legacy of this president. And that is, it was a series of libertarian conservative bloggers who came up with the theory that this statute was unconstitutional. The idea was, yes, we see that Congress can regulate commerce between the states. Got it. Yes, we see that healthcare involves trillions of dollars in commerce. Okay. But what's going on is that Congress is requiring you to buy insurance. It is therefore creating commerce, not regulating existing commerce. I think this is one of the stupidest arguments ever. And that was the conventional wisdom when it was originally made. And it was just developed and expanded and made concrete in this way. And that's through a set of intellectual posts on blogs, including one called the Volokh Conspiracy. And it turned into a thing, and it almost radically transformed.
It won the day on the Commerce Clause.
It did. It absolutely did. And that is, the statute was upheld on another theory. But it was remarkable that this law almost bit the dust because of this argument. It was only the administration's backup argument about taxing that it was.
Presumably, they wish they did not have to.
Yeah, I mean, they wish they had the commerce power. It's not, Congress doesn't often, this doesn't make a huge doctrinal difference. Congress doesn't often go and tell people, you have to buy this. In fact, it never does that. But it was the concept that this massive piece of, congressional legislation that has a humongous effect on commerce in the United States would be invalidated as beyond the commerce power. I think that the chief decided that, based on principle and what he thought the right answer was, I do think it is a happy coincidence that the decision, by and large, has reinforced the public perception of the court as an objective institution. It would have been very bad if the 5 Republican nominees to the Supreme Court had voted to strike the statute down in an election year, signature presidential achievement, massive issue debated in the Congress for many decades, and the 4 Democratic appointees had voted to uphold it. That was just not gone over well. Now, the chief took holy hell from conservatives who really tasted blood in the water and thought that this was an outrageous expansion of federal constitutional authority in all, sincerity. But that, I think, will blow over for him. He is a conservative jurist. His opinions will continue to reflect that. So I think it all kind of worked out well. The echoes of the case haven't really been heard yet, particularly with respect to that spending clause thing, when it is that Congress can require the states to do something while pulling back the purse strings. But it was whisker close. It is extraordinary. My hope is that the public thinks well of their Supreme Court for having tackled it and come out in a reasonable way.
It's possible that the Republicans are now less unforgiving of Roberts letting the law go into effect. It seems that it's possible it would have been a better issue as a martyr for the Democrats than as a living
There is that irony to it too. The political process, which was allowed to play out, has caused the president and Democrats a significant amount of pain that they would not have experienced politically if they could have been doing with Obamacare what they had tried to do with Citizens United, for example.
Right.
And that is go to war with the court, which they were fully prepared to do. They would have been in a better political position, that's for sure.
Are there questions?
I'm afraid after what you said today, it may be very unlikely that you yourself will ever be nominated to the
This was
Supreme Court.
overdetermined, sir.
Because it would be so easy to misunderstand what you said about the court as a policy-based institution.
Yeah.
And I would like to ask you about your view of the system of the confirmation hearings. There are always these complaints that sort of it's not possible anymore for candidates to articulate any interesting view of the Constitution. They all have to say we just follow the law and so on. So what's your view? Do you expect, is this a dead end? Will this ever change?
Yeah, I think it's a very regrettable situation. We have, two terrible things going on in the confirmation process because we want smart, interesting, well-read, opinionated, thoughtful people to be nominated as judges, not just machines. Because machines can. No, I don't know that you really want me. But people who have a strong vision of the law, and that is problematic for 2 reasons. One is just the politics, and that is almost reflexively every Democrat votes against every Republican nominee, every Republican votes against every Democratic nominee. Then we have the still horrible problem that you identify, and that is that because of the former, everyone is looking for any possible excuse to oppose a nominee. That means 2 things happen. One you've already described, and that is the nominee gets up there at the confirmation hearing and says nothing. Says Roe versus Wade, yeah, I've heard of it, but you know, I've just never really, it just hasn't come up. So we get a little bit of that, which is unfortunate, so you don't really know your justice going in. And the second is, and this is even more troubling in my opinion, we are headed in the direction of picking nominees who genuinely haven't said anything about those issues. And so they are essentially a blank slate. And people who want to be nominated to the Supreme Court are not writing about, not thinking about, and are trying to keep themselves Sphinx-like so that they are available to be nominated to a Court of Appeals and then to the Supreme
So
Court.
they should never blog. If they want
Yeah,
to.
well, and they don't. You know, I will say that most of the people who do what I do are incredibly reserved, express very few opinions, don't enjoy doing a huge number of the things that I get to do because they are waiting for the phone to ring and the president to call them and say, I finally recognize you are here to save the country.
That, by the way, is not just true in Supreme Court nominations, but nominations to the State
Yes.
Department or virtually anything.
Yes.
More and more people, because of any kind of questionable paper
Yeah.
trail, interesting paper
Yeah.
trail, are simply barred from office.
Yes.
It's fascinating. So for people like you and me who sort of say, I don't want to go into government service.
It's very liberating.
It's very liberating, and also there's less competition because a lot of smart people
That's
are
true.
keeping their mouths shut.
That's
but
right.
it's not good for the country.
It is a shame. There was an era when it was the case that the people who were really interested in things and who were relatively smart would go out there and write and talk and think about them, and they would then get important positions in
Exactly.
the administration, and they would be respected even by their opponents because they were the best people in whatever field it was. So that has changed a lot. It is now so easy for similar reasons to the existence of blogging to mobilize a political opposition to
Right.
any person based on the thinnest possible rationale.
And there are all these sudden death networks out there ready to come down and somebody like a ton of roof.
Is SCOTUSblog able to play a constructive role? I mean, I know that in a couple of the hearings, you actually broke your usual silence, and there was one point where you said, stop the personal attacks
Yeah.
on your blog. Have you found that SCOTUSblog has been able to sort of focus people more on the issues and less on the personal attacks and less on that? Or is it?
I mean, I'm very modest about the role of the blog. I don't think you can ever say that something for an institution like SCOTUSblog, as opposed to some major national institution or national figure, that you change the discourse. I will say there's probably one example of that, and that is when Sonia Sotomayor was nominated to the Supreme Court. There was this wise Latina remark, and it kind of took hold as a caricature of her as being, very focused on race and very in favor of racial preferences. And I went and I read every one of her opinions, and I put together all this data about how she voted in race-related cases compared to Republican appointees and other Democratic appointees. It showed it was all crap, right? And then just published that, and the next day at the daily briefing at the White House, they talked about this piece. It was not solicited by them, I just did it. And that seemed to put the kibosh on that. That is, over the course of 15 years, that you can only point to one thing. We try and when people are going overboard about the court or the justices individually, and I think it is baseless, then I will step in. I'm not there to just defend the institution. As I said, I've testified on cameras in the courtrooms in Congress where nobody else in the bar would do something like that. But we do now have this, this degree of respect as kind of a voice of reason, and I pick our battles very carefully, and that is there'll be 2 or 3 times a year where I'll say, okay, here's I think the deal. And people, I'll say, I wrote a year beforehand, here's what's going to happen. Justice Stevens is going to retire. Justice Ginsburg is not going to retire. Elena Kagan is going to be appointed to replace Justice Stevens. And, if you just play out your whole story and you aren't constantly out there kind of lambasting people, then people will pay attention. And so I'll do things like that.
You talked about what makes you successful as a blogger, with why viewership is different from what makes you successful as a justice, a professor, or a Supreme Court litigator. I mean, how do you reconcile this as you're running the blogger at the same time while you're practicing yourself?
I actually blog relatively, that I am a publisher in that respect. And I don't, the difficulty with me blogging about what's going on at the court, you can tell I don't lack for opinion about the Supreme Court. So it's not that. Or lack for a willingness to express an opinion about the Supreme Court. I believe that they're grown-ups. I believe that because they know I respect them, they don't get annoyed at me for saying what it is that I have to say. And because I'm not an ideologue about them. I don't go off and say I think the Roberts Court is a bunch of conservative hacks or that the left is a bunch of crazy liberals. But I like building institutions. And so my legacy with SCOTUSblog, unlike most bloggers, is not what I've written. To the extent it's anything, it is building this forum where a lot of people who kind of know what they're talking about can come in and write. I blow hot and cold about whether I want to, practice a little bit less and write a little bit more. I'm getting to the point after practicing it at the court almost exclusively for 15 years that I finally view myself as competent to really write about what's going on. I think it's that complicated a place. And so I am thinking more and more about writing like every week on the blog, which is something that I did in the very early days, but when I started teaching and when I started practicing, we have so many cases at the court, and that my responsibilities to my client keep me away from writing. So most of what I do is I do technology, I do direction for the blog, I do policy for the blog.
Can I ask a follow-up question? So the blog has transformed a lot from when you first started in your bedroom, right?
Yeah.
While getting those viewership, you get more respected.
Yeah.
And do you think those sometimes with those respect give you more responsibility and constraints that maybe makes the blog harder or easier to run?
Well, I think it's a very good point. That is, if I say something on the blog about the Supreme Court, a lot of people are going to think that it's true. Maybe they shouldn't. If they knew me better, probably they wouldn't. But if I say, someone's going to retire or this case is wrongly decided, the Supreme Court press corps pays enormous attention to the blog. As with the stuff that you do, there's a kind of a cadre of readership. So it's not just kind of the people who read, the kind of the members of the public, but there is an echoing effect outward from the blog when it comes to the Supreme Court. That something that gets said on the blog, particularly if I say it, we can convert into conventional wisdom. And that means that I have to be more careful. If I get mad at somebody, I can't just kind of go on there and blow them away.
No, it really does get, in a funny way, the more that people listen to you, since the less you can say, or at least the more carefully you have to say.
You ought to.
Yeah.
You ought to. Frequently it doesn't work out that way. But I think it's a good point that there comes a greater measure of responsibility. If you're just there screaming into the wind, then have at it. And it's also will reflect back on you. I'm not just saying that I can say something stupid, people will believe it, and then I'll be fine. If I say something stupid, some people will believe it, and then they'll think about it for a minute, and they'll start to realize that I'm stupid. And if you just don't want to. That's again part of the reason that I hold my fire. And that is, if I say something, I really want it to be something that's material.
Do you have an editorial process where how many people read a piece before it goes up, or if Lyle writes something, it just goes up?
It is edited. Every piece that is not breaking news is edited. We don't have, other than for breaking news, no one has the capacity to just write and publish. I mean, I could, but I don't. But it all goes through Amy, who is an editor. Anytime that there is a substantive issue, she will send it to me. So there is both the writing check, which I think has been very important. That you write well is actually material. You can have the best ideas terribly expressed, and people will just get frustrated and stop reading. And so the fact that we have put in place, and Amy is an extremely talented editor, the fact that she goes through every piece carefully and that isn't filled with typos and things actually makes a big difference. And the fact that I can look at the pieces and I understand the cases and the justices and where they're coming from, that's a big difference from an editor at the New York Times. An editor at the New York Times can read the piece and make sure that it's grammatically correct. An editor at the New York Times has a much harder time figuring out kind of, is this piece correctly describing the law? So we do have both.
And it's, it really is, I think a young person, again, might have a different strategy of no one knows who you are.
Yeah.
You know, you want them to
Yes.
pay attention, and you'll take a few risks to
Yes.
get out there. You don't want to be stupid, but once you're the custodian of an institution or a reputation, then you guard it. So you have different approaches.
I agree with that. That reflects what I did at different stages.
Yeah.
That I would say some things that were a little wilder out at the beginning to get attention, subconsciously or not. And there are people out there, I will say that there have been multiple blogs created to hating either SCOTUSblog or me personally. Why people have so much time, I don't know. And the best thing, and so they are, trying to draw attention, or that was entire blogs. People will write long screeds about me or us from the left and the right. But the best thing to do to that person that will drive them absolutely insane, and I mean literally to the point of needing medication, is just to ignore them.
Yes.
It's
Yes.
amazing that they just feel like you have to get engaged in this war with them because they're saying such nasty things
Right.
about you.
Right. Number one rule on the internet: do not feed the trolls.
Yeah, absolutely.
Do not feed the trolls.
And the cousin of that rule, I agree with that absolutely. Rule number 2 is, as a consequence, don't let your blog be a forum for the trolls. This is sad. For a long time, the SCOTUSblog would be a particularly ideal forum for discussion about the Supreme Court if you could comment on it. And you could engage in a rational, reasoned discussion with other people. And you could ask questions, and we would answer your questions. It turns out, however, that most people who take the time to write on the internet are idiots and lunatics and unbelievably opinionated, and it's a very sad situation, and that is, it's a cousin of the phenomenon that people blog the more interested they are. Well, the people who hang around on the internet and write comments on blogs all day and newspaper, you've read them, right? You all know what I'm talking about. And it's a sad, sad state of affairs that it's very difficult to separate the wheat from the chaff. And so we have one example where we do it, and that is that we do live blogging. When the court is handing down opinions, you can come to the blog and you can just ask us questions, and we will answer your questions about anything, because then we can filter out crazy people.
You just answered my question. I was wondering, because I know, Walter, you turned your comments on and off. Comments on the internet often tend to be terrible and written by lunatics. On The Economist, there happens to be quite a good discourse.
There are places that manage somehow through curating and through tradition. It's very hard to build that.
But I think it requires a substantial investment in the curating. I think that's very hard because somebody has to spend some staff time with that.
Yeah, absolutely. And there are new technologies that allow people to promote good comments
We do that.
and demote bad comments. So there is that, but it's very hard. And the difficulty is so much of what we're writing about is so technical that nobody will comment. So it's a dilemma, and it's a shame, because I really would love for people to come and talk about their Supreme Court, and we'd be a really good place to do it, but it's just that they get trampled over by lunatics.
You find some amazing sort of sophisticated trolls as well as I find, for example, a lot of people are always, for some reason, there are a lot of racists out there who are desperate to see their ideas in some sort of a forum. So they'll start talking about themselves as human biodiversity things, and that's the new code word for saying that different races have different abilities and so on and so forth. And you find all of this stuff. It's so bizarre that people are so perverse. It's a shocking look at the underbelly of the world.
I agree with you entirely. I am sorry to say that it has caused me to lose a substantial amount of faith in humanity. I mean that literally. Because it's really interesting is you walk by people on the street, right?
Yes.
In your ordinary daily life, what proportion of them do you just look at a person, you don't have any conversation with them, and you think that person is pathologically insane and a racist and a misogynist, and they basically are very concerned about the implants that the CIA has planted in their heads. It turns out a lot more than you think. If my comments on our blog are any measure, what people are willing to say when anonymous is extraordinary. You take their apps off.
When you turn off the comments, that's one driver of traffic that you don't have.
Yes.
Right?
It doesn't make, it hasn't made a huge difference either way to us, I find.
I mean, it does reduce, and hence the fact that newspapers, like the Washington Post or whatever, do have a comment feature. They don't really care what people are writing, and they know that it detracts from the site. But people will come and hit refresh or whatever, and their page hits and their advertising will go up as a consequence. And I don't care. I concluded that the comments were making the site worse rather than better. That people were thinking less of us because they were associating what was written by the commenters with us, even though they knew it wasn't us. And I have yet to find a solution to that. I have thought about, trying over the course of, I would invest years if I could get a group of 2,500 commenters that I trusted, right? If I could get a community and they had to register and all this sort of stuff, but it's a huge amount of work, as you suggest.
But that is probably, in some ways, that would be a very good solution, that a blog would be an individual or a group of individuals, and then around them is this kind of concentric circle of people who are interested in the same stuff and have some credibility and character.
Because when it works, it is a beautiful thing. And I will say that, and that is that the people who write for our blog don't have anything like a hammerlock on insight to the subject matters of what the word is doing. And if you can get a community of people, you see it sometimes in the Bold Conspiracy, something like The Economist, you can really get wonderful insights. The delta between the really good participation and interest and what ordinarily happens is massive, and its ability to contribute to good discussion is extraordinary. And so when somebody cracks that code, they will have done a lot of good.
Well, I mean, if you were just to pay someone to go through the comments, could you do it, or is there something that prevents? Because I know you used to.
Yeah, we've tried all kinds of
Curate.
things. I now have the resources to pay someone to go through it. The difficulty is this. If a reader believes that their comment is subject to deletion, they are less likely to participate. It is the very notion of these schemes existing. It's hard to get your critical mass. If you can get to the point where there is a conversation going on, then they will participate. But getting from here to there is hard. I don't mind spending the money.
And to do it well, it would require, I think in some ways, that you reach out to some of the commenters that you want to attract.
Yes, no question.
And
They
they
have to
and they know, and you're responding sometimes to their comments on the site so that they feel they're breaking the wall.
Yes.
They're getting backstage.
Yes, that's right, and that they will get attention. That it's worth the investment of their time.
Exactly.
Because most people who are quite knowledgeable, this is the difficulty. If you know a lot about something and you can express it well, you generally are already well enough established in enough forums that you don't need to be spending your time writing comments on a blog, right? There are already people listening to what you have to say somewhere else. So finding that kind of magic level of intersection where it's worth the investment of their time to write something because people will really read it and respect it, getting from here to there is very difficult, but extraordinarily worthwhile. If we could ever do it, it would be fantastic.
Can you just give us a couple of websites or blogs or Twitter feeds or things that you follow that you find maybe might not be well known, but that you, where are the places you look for your information about the law?
Well, we have an active effort to curate discussion of the Supreme Court everywhere. Every day we have a roundup, and so we aren't focused on any one place. And the press corps related to us is a discrete group of about 10 people, and they're kind of the usual suspects. The Volokh Conspiracy is an excellent blog that I've mentioned. There is another blog. There's that blog, and another one was created at the same time as SCOTUSblog that is itself like Instapundit, and that is it's kind of just a series of links, more ideologically objective than Instapundit, but about kind of big picture legal things, and that's called How Appealing, which I've been a long time fan of. And then, I am a big fan of people who just think interesting things and are willing to write them. The kind of the usual suspects, the kind of Andrew Sullivan type writers, and I don't really care about their ideology at all. I find that if you read good writing, you will think more clearly, think more interesting things, and you will write infinitely better yourself. My problem as a lawyer is I read a bunch of crap, I read a bunch of legal briefs, and we all kind of trend in the direction of what it is that in the sentence form or whatever, that our brains are used to. And so finding people in the law who are writing really interesting stuff in neat ways is super duper hard. If you are coming out of college and you are just like really intellectually interested in a ton of things, if you are really good at expressing yourself, you don't go, I'm going to law school, right? That's not the kind of person that I am or that the other people who went to law school are, which is unfortunate. The law could benefit from tremendously.
All right, well, that's one last question.
Content aside, I wonder if you have any comments on website design. And it seems that you've taken an approach to SCOTUSblog which is quite spare visually,
Yes.
and you don't draw attention to particular posts by showing this number of shares, this number of Facebook shares or tweets.
Yeah.
Can you talk about why you chose
I
that?
care enormously about design. I actually care a lot about the visual component of the blog because I think that it matters. People experience it in a more positive way, are more willing to come back if it's easy to navigate and enjoyable to read. And so the classical blog, which is just a scroll, is super duper boring and uninteresting and not that informative. The principal difficulty we have is that the Supreme Court is not a visual place. It is a bunch of briefs and lawyers, arguments and opinions, right? There's nothing that ever happens. My life is very dull. If you were to see my Instagram account, it would look like this room, okay? And you are wonderful people, but it just wouldn't be visually arresting. And some exceptions. But what we have done, so I've tried hard to work around that. I had a photo editor for a while, trying to associate images with particular cases. But now what I've done is I've hired one of the sketch artists, Art Lean. And so we sometimes change the banner, and we do sketches of the oral arguments, and we put them in. And that has helped a little bit. I'm mostly concerned about navigation rather than promotion. And that is, we do highlight featured posts, but our volume of content isn't so massive that you need to come to SCOTUSblog and say, which of the 5 posts from the day is, particularly interesting. Because I've always believed in blogging, you need to get on people's into their daily pattern. If it's when they think that you are doing something every day that it's worth visiting for, that's when it will take hold. If they're thinking of you more episodically, that they're coming, when they think of something about you, then your readership is going to be much lower. You need those people who is just part of their daily routine. They go to the NewYorkTimes.com, they go to the Wall Street Journal, whatever, and they come to SCOTUSblog. And for that reason, I feel that our core readership is seeing all of the posts, and I don't have to do something for them that says, and I've never been asked to really. On the other hand, the architecture of the blog is extremely complex, vastly more so than almost any other blog, because of its archival function. That we have this layered underneath this scroll of things are all of these case pages and statistical sections and special features and that sort of thing that I have spent a lot of money having people code in WordPress and what is a complicated website.
Does WordPress do all of those things?
WordPress, yes, WordPress does everything. You can twist and contort WordPress to do. I've included almost anything, and so I care about people being able to find things, and that's my biggest dilemma. And that is for someone who isn't versed in the law and so doesn't really understand the structure of cases and those sorts of things. How is it that I can help them find things? And so there'll be an entirely new banner system that'll come out probably next week that's intended to do that. Our search feature kind of sucks. I have to get that figured out. It's better now than it used to be. You can, for a time, it's been easier to search SCOTUSblog through Google than through SCOTUSblog. But it's easier to search the Supreme Court's docket through SCOTUSblog than it is the Supreme Court, so it's kind of a tie. But I wish, and I should also say we've added video features. And that is, there's now a video player embedded on the right. where we pick up all the video of the justices doing speeches, and we do our own video interviews ourselves. So our difficulty is that our subject matter just isn't that amenable to the visual component, but I struggle mightily because I want it to be, because I think that the human mind and our culture are visually oriented, and you can engage someone much better. People really watch a lot of local television
You
news.
said Fox has found one solution to this problem.
Yeah, I could just scream, but
have blonde hair.
yes, I know.
and,
I can't do that, so I can just scream. I think about this a lot. It's one of the principal things I do is trying to make and I do reader surveys to try and figure out how to make it better. The blog is now on its, unlike most blogs, the blog is on its 6th distinct platform. Just rewriting it completely.
Thank you very much.
Thank
Please
you.
help me, Joyce.